Inheritance tax continues to be a divisive issue amongst Belgians. Here to shed light on how the taxation industry is evolving is Jonathan Chazkal. What are the principal as well as the applicable rates relating to inheritances?
The general rule in Belgium is that you pay taxes if the deceased passes away in Belgium, if his last residence was Belgium. If that's the case, all the heirs of that deceased person will have to pay inheritance tax on all the goods that were belonging to the deceased person on the day of his death. The applicable rates can go up to 65%. For example, if it's in direct line from parents to their children, the applicable rates go up to 27%, but for a brother or sister, it can go up to 65%. So it's very high rates, so it is sometimes important to try and avoid them.
Now, who's ineligible for these higher rates?
If on the day of death, the goods do not belong anymore to the deceased persons, the heirs will not have to pay inheritance tax on these goods. So, for example, there would be donations given during the lifetime of a person, and if a donation is made, then on the day of death, no inheritance tax would be due on that good. However, if the deceased person passes away within a delay of 3 years of the moment of that donation, then the heirs will have to pay inheritance tax. If you want to avoid that inheritance tax, then what the deceased person can do during his lifetime is when he gives out the goods to, for example, his children, he could register that donation for a rate that's 3%. If it's a donation to someone else than in direct line, the rates are of 7%. So in any event, if you would then pay 3%, then the heirs would not be eligible anymore for inheritance tax.
Sitting across the table from one of your clients, how would you suggest that they devise a strong inheritance plan?
The idea is to not be owning the goods the day of death. So either do donations during the lifetime of a person, or you can, for example, regarding real estate, you should know that donation tax to pay with real estate are the same as the inheritance tax. So a solution would be, for example, to bring in the real estate into a company in order to donate the shares, which then would be much cheaper than donating the real estate itself. Finally, a system that is being put forward in Belgium lately is the system of a trust that the UK, for example, knows as a structure. In Belgium, the Belgian law does not know the trust structure, but the international law does know it. And so if, and under very strict conditions, the trust is discretionary, is irrevocable, then it would be possible for the beneficiaries of such a trust not to be eligible for inheritance tax if the grantor passed away.
Fascinating. Jonathan, thank you so much.
Thank you.